Yeah, now you guys live.
Okay, so we can begin.
Okay, best of luck.
Thank you.
All the
Thank you.
best.
Thank you. Okay. Good evening, everyone. I am your host, Isabel John, and I am a column writer for Law Insider. Welcome to Law Insider's study program on the High Court Litigation series. This series will take place over the course of 3 days. Today is the first day, and the topic is bail. So, what is bail? It is the process of releasing a person from prison who is under trial or appeal by the fulfillment of proper paperwork and security to ensure his submission at the required time to legal authority. Essentially, bail denotes the provisional release of the accused in criminal cases in which court the trial is pending and the court is yet to announce the judgment. Individuals can use this time to collect evidence, talk to their lawyers, and other such things. Everyone has a right to bail if it is a bailable offense. There are 3 types of bail: regular, interim, and anticipatory. Tomorrow, the topic for discussion is anticipatory bail. As mentioned previously, this is one of the types of bail. Finally, on the 17th, which is the last day of the topic, is the Gangster Act. We are very pleased to have our esteemed guest speaker, Advocate Ravi Jha, here today to speak to us. Mr. Jha is part of the Defense Counsel in the Allahabad High Court. He was born in Prayagraj on the 2nd September 1989. He pursued his BA from Allahabad University, from Amity University, and his postgraduate diploma in IPR at the Indian Law Institute. His specializations include criminal law, arbitration, and family law. He practices a number of cases related to bail, gangsters, and criminal appeal matter. Join me in welcoming him here today. Thank you.
Very good evening to all of you. Myself is Ravi Jha, and I'm a practicing advocate in Allahabad High Court. And thank you so much, the platform of Law Insider India, and thank you so much, Isha, for briefing us about a brief description of about the whole concept of bail, not in a broader sense, but you very well explained in a very brief description. So today we are going to discuss the concept of bail. We all know that very well what is the concept of bail in a very initial stage of our leading our law life. But as today we are going to discuss the concept of bail, so first of all, we will have to describe the concept of bail into 3 parts. In the first part, we will discuss the whole concept of bail, the object of bail, the definitions of bail as per the various jurists, as well as the opinion of the Supreme Court as well as the different high courts from time to time. In the second part, we will discuss the whole concept of Section 436, 437, and 439 of CRPC, in which we will discuss the concept of bail in a bailable offense. We will discuss the concept of bail in a non-bailable offenses, and including we will also discuss the concept of interim bail. And in the third part, we will discuss the whole concept in what kind of way or manner we file a bail application before the Honorable High Court or the Court of Session with the help of Section 439 of CRPC. So, if we are going to discuss the concept of bail, so first of all, we should know what is the meaning of bail. First of all, we should know the concept of bail has not been defined in anywhere under the provision of Criminal Procedure Code. And if the question is what is bail, so we can say like this: the bail may be regarded as a mechanism whereby the state develops upon the community the function of securing the presence of the prisoners, and at the same time it also involves the participation of the community in the administration of the justice. If we talk about the law which generally apply over the bail, so we can say that, namely, on the one hand, the requirement of the society for being shielded from the hazardness of the people exposed to the misadventures of the accused person, and on the same time, on the other hand, the fundamental canon of the principle of criminal jurisprudence, that is called the presumption of an innocence of an accused till he is found guilty. We can also say that is bail is a recognition of the presumption of an innocence. Bail blends the two apparently conflict view. In the first side, the freedom of the individual and the interest of the justice. The provision of bail also restore the liberty of the arrested person without jeopardizing the objective of the arrest. Therefore, the general rule is that bail is not a jail. Normally, these quotes we hear when we entered first time in our law schools. Until date, we are here. Even in the most of the cases, Supreme Court has also expressed their opinion until and unless you don't have the last authority as well as you don't have the last option to secure the presence of the accused before the competent court. This is not the lenient way, this is not the right way to just catch the person and to put behind the bar. Because we also govern by the Constitution of the India, and we know that very well. Constitution is mother of all the laws. There is a no doubt. But on the other side, if we talk about the brief description and the content of the bail, so we can say like this: the bail is one of the cherished right that is claimed as well as the privilege of by the hand of the accused person. It is one of the most dignified institution in any civilized society in which human values such like faith, trust, take precedence over everything else. The release on bail, it doesn't mean that person is free from the justice and the person is free from the accusation. It just gives a temporary period of time to the accused person, or we can say to the suspected person, even though he can better prepare himself in the form of case through his counsel or through his relative. Because we can put a person behind the bar only in exceptional cases, not in a general sense. It is a crucial to the accused person, the jailed accused or the suspected accused person subject to the psychological and the physical deprivation of the jail life. Because of that, he loses his life, he loses his dignity, he loses his everything. You won't be believed that a person had facing a charge of rape and he was behind the bar more than 10 years, and the sentence has been passed before the competent lower court. And when he filed an appeal before the Honorable High Court of Judication at Allahabad, and you will get surprised that he is completely get a justice and he declared not guilty. Now the question is that who is responsible for the loss of more than 10 years of that person who has suffered a lot of pain, a lot of mental pressure, a lot of social economic pressure, just because of that he was booked under section of 376 of the Indian Penal Code. If we talk about the object of bail, so normally we should know what is the object of bail. Next slide, please, Isha. Okay, if we talk about the object of the bail, so first of all, we should know the principal purpose of bail is to ensure that an accused person will return for trial if he is released after his arrest. That means bail is only a discretionary right only in a bailable offense. वहां पर that is your mandate right. If you have committed any kind of bailable offense and if you are willing to furnish security, if you are willing to furnish their respective terms and conditions, so normally even though the police officer as well as the court will grant you the bail. But if you are not ready to furnish the security, if you are not ready to furnish to the bail bond, despite of that you are seeking the bail order. So normally this is not practically possible. Of course, it is practically possible only in the case of indigent person, not in the case of rest other. So it is clear-cut indication that in considering the question of the bail, justice of both the sides should be governed and the judicial exercise of the court as well as the judicial discretion. That means, on the other hand, the applicant at present time who might be a suspected person, who might be accused, he will also have to prepare their basic pro forma, and the other side, the prosecution, he will try a lot of things by which he can stop to grant the bail by the order of the competent court. And the another side, this is also the work of the judiciary to check out all the facts and the circumstances whether that person is eligible to get a bail or not. If this is in the interest of the justice, the person should be released behind the bar. That means judiciary will have to check all the facts, all the circumstances, all the minor to minor things which will facilitate for the flee from the justice. Not in that sense the person will flee from the justice. The sense is that he can fired only behind the bar, because it is the rule of law. Both parties should be heard and no one should be condemned without the process of the hearing. That means if we put any person after booking the provision, different provision of the Indian Penal Code and the different acts, and if we sent that person to the jail, it doesn't mean that that person is an accused person. There might be possibilities after the completion of the trial or before the filing of the charge sheet, his name has been struck down from the charge sheet and he will be completely declared by the competent court to the innocent. Because in a criminal law, we know that very well. Until and unless you will not declare the person guilty beyond the reasonable doubt, because this is not a civil case in which you have to weight the balance 49% or 51%. You have to prove the guilty person beyond the reasonable doubt until and unless that person will not come within the different provision of the IPC in the form of exception, as like a exceptional clause in which the person will have to prove that he was taking a ground of the general defense or the general exceptions. So, bail is a matter of right one side, and the another side, it is also a matter of discretion by the court. But before granting a bail by the competent court, this is the duty of the judiciary. He will have to check all the essential requirements before granting the bail. Apart from that, he will also have to explain the speaking order, that is called reasoned order, in which the particular competent court will have to mention on what kind of ground he is releasing that person on executing bond as well as the sureties. If that competent court is not declaring any kind of reasonable ground, is not mentioning any kind of comment or note, so that is subject to judicial review by the competent higher court. And by this kind of way, normally the High Court or the Supreme Court, they check whether the order of the bail is really executed in the same way, in the way the principle of natural justice will follow, or it is a matter of simply arbitrariness, in which nobody is going to check what happened. You just pass the order, and the higher court and the Supreme Court, they will not check on what kind of circumstances, on what kind of ground the certain order has been passed. So, while granting the bail application or while discussing the grounds of the bail, the judiciary will always have to open their eyes along with their minds. Because all the content, whatever has been mentioned in your bail order, Normally, whenever we will challenge before the higher court, it might be a high court or it might be a Supreme Court. We will check. Here, we means the competent high court as well as the Supreme Court of India. Even though the Supreme Court will take in the form of special leave petition, not in a general way. That is the main reason it has not been mentioned in your Criminal Procedure Code 1973. If we talk about the second object of the bail, then we will get it. The object of arrest and the detention of the accused person is primarily to secure his appearance at the time of the trial, because only the trial will decide whether you are a guilty or you are an innocent person. It doesn't matter the police officer has wrote an FIR against you and you behind the bar and you are guilty. No, this is the prima facie procedure by which any investigation is going to be started after the registration of an FIR. So FIR, you can say it's just a piece of paper. It's not a substantive evidence. It's a clear-cut judgment by the competent court. So at the time of the trial, the presence of the accused as well as the opposite party must be a mandate provision, because we also governed by the Indian Evidence Act, where the process of the examination in chief, cross-examination, and the re-examination. And if the person is not appear before the trial, the opposite party is not present at the time of the trial, who will conduct the examination in chief and to whom he will conduct the cross-examination if party is not neither present nor their litigant are there. So normally, the primary object of the bail is just to ensure the presence of the accused person before the competent court at the time of the trial. And it is ensured that in case he is found guilty, he is available to receive the sentence. This is the main thing which you will have to understand. We have seen a lot of movies, we have seen a lot of web series, and you have also observed a lot of things in day-to-day life. So normally you can say like this, while passing the sentence, even by the lower court, we can say like a court of session or the district court, even sentence has been passed by the High Court or the Court of Supreme Court of India. This is the mandate provision while passing the sentence, the person to whom the particular court is passing the sentence, that person must be present in person before the court until and unless his physical condition is not allowed there. Because every person has a right to know by what kind of offense he is going to be punished till his last breath. That is the main reason. If the person is behind the bar, so normally the court call him in the police custody, and this is the duty of the jailer, or this is the duty of the superintendent of the jail. He will have to arrange all the facilities to convey the accused person from jail to the competent courtroom, because on that particular date or the particular time he will receive the sentence. And it is also the well settled law of the criminal jurisprudence that most of the cases the sentence must be conveyed directly to the person against whom a trial has been conducted in an appropriate way or manner. If his presence at the trial could be reasonably ensured otherwise than by his arrest and detention, it would be unjust and unfair to deprive him of his liberty during the pendency of the criminal proceeding against him. That is called what? That is called until and unless the unavoidable circumstances has been not arises suddenly. So it is the duty of the court that person must be there while receiving the sentence. Isha, next slide. Okay. Now, we should also know, we have discussed the what is bail. We have also discussed the what is the object of the bail. Now it's time to discuss the definition of bail. We have gone through the Criminal Procedure Code. We have gone through the different books which has been incorporated. But particularly in the field of criminal procedure code. The definition of criminal procedure code has not been defined in anywhere into the provision of the Criminal Procedure Code Act. It is clear. But from some time to time, different views which has been passed by the Honorable High Court, different views which has been passed by the Supreme Court of India, different views which has been passed from time to time by the hand of the different jurists. They have beautifully explained the meaning of the bail. But we can't say like this, this is the definition of bail. Because definition, it's a kind of interpretation that means you have to take in the same sense, in that sense, the person has interpreted in your act. So we can say the term of bail has not been defined under the CRPC 1973 Act, even though it has been defined in the law Laxian as a security for the appearance of the accused person on the particular time, on the particular date, on the particular courtroom at the time of the trial, or whenever, whenever the court will ask their physical presence, that is called in person. Normally, when the court call any person, no, you have to just come before the court and we want to see you. We want to ask some question to you. So it's clear-cut indication that the honorable court is calling that person, that is called in person. Otherwise, you can also appear through your counsel, in which normally the accused, that person is not actually needed to be present in the court if the court has been ordered through counsel. But whenever the court will pass, whenever the court will pass, no, you have to be present in person. That means you have to be present in person before the competent court at the particular time, at the particular courtroom, without any undue delay, which cannot be delayed. So we can say the word bail means to set at liberty a person arrested or imprisonment or a security being taken off his appearance in the court on a particular day. So that is called, sometimes we can also say the word bail covers also own personal bond. Own personal bond, that means if you will not fulfill and if you will not follow the condition which has been incorporated in your bail order application, which has been already passed by the competent court in your favor. That is called what? That is called your personal bond. Personal bond, that means until and unless you will not submit sureties, you will not submit your personal bond, you will not release from the judicial custody. Look, suppose the honorable court has passed the order of the bail. Your relative got the order of the bail in the form of certified copies. Then you approach to the concerned court. The concerned court, normally we can say it's a lower court. Normally he will collect all the sureties paper, he will collect all the bond paper as per the direction of the competent court who granted your bail application. And you doesn't have a sufficient means, and there might be possibilities you have a sufficient bail but you are not showing. So do you really think so you will get a bail? No, this is not. This facilities is available only to those persons who are really indigent in the eyes of the court. And for this purpose, the court has set a criteria. And the criteria is what? If the person who is in the jail, already the bail order has been passed by the competent court, in which certain terms and condition restriction has been imposed as per the circumstances of this case. Court also ordered, you have to submit two sureties along with bond. The value of bond might be 25,000, might be 50,000, might be 2 lakhs or 50 lakhs. But that should not be excessive as per the current financial position of the accused person who is behind the bar. Suppose if the person who is belongs to a very middle class family, even the council as well as the court, they know that very well. That person is not go beyond the limit of 50,000 and 1 lakh. And the court passed the order, you will get a bill, but first of all, you will have to deposit a amount of 10 lakh bond paper in the form of surety as well as the guarantee. That is what? That is what, in a real sense, the judiciary is still not letting the person flee from the jail. That is the main reason when argument is going before the competent court and the and the prosecution is trying to frame that person. No, that person is not in a good sense, and there might be possibilities if that person will released from the bail, if he will get the bail, so he can escape from the custody, he can escape from the India, he can tamper the evidences, he can also threat to the societies. So normally what the court says, the court will have to look all the antecedent of that particular suspected or the accused person. The statement which has been conveyed by the prosecution officer, is it really worth, or it is just to mislead the court? And while court imposing any amount in the form of bond paper, so it is the duty of the defense counsel to state the truth act, the actual condition of the accused person or the suspected person before the competent court. Because until and unless you will not fulfill the terms, conditions, rules of the bail order, you will not get a bail. That means you will not release from the judicial custody. That is called, might be central jail or the any reformative center. We can understand in a very well manner. So it is also the duty of the court while granting the bail application. First of all, he will have to check the financial position of that person, and if the court is really willing to give the bail, so he will also have to look the terms and conditions. It doesn't matter the terms and conditions should excessive in vague, or it cannot be practically practicable or practically holdable by that person. So while granting a bail and when the court is writing any kinds of terms and conditions, so he will have to take care as much as they can. So we are discussing what is the definition of bail, and we have already discussed nowhere in the concept of the CRPC the term bail has been defined. But from time to time we got some interpretation in terms of the bail. So the word bail means what? To set a liberty a person who is arrested or who is imprisoned. If we talk about the detailed interpretation of the bail, so we get it by ensuring his future attendance in the court for a trial and compelling him to remain within the jurisdiction of the court. Because we know that very well, we have a one Supreme Court of India, we have a different high courts in context to respective their states, and in each state there is a division, session division, in which one is called district judge, district judge, additional session judge, and unke niche there is a lot of number of the judicial magistrate, first class, second class. In some family courts also, there is a special appointment of their respective judges. In POCSO, in NDPS courts, they have already established or they have already set up their specialist judges who deal particularly their respective cases, and it is the discretion of the district judge of that particular session. He may rotate, or he can reshuffle their fix matters in between of them. It doesn't matter the person who will look only the NDPS Act till his retirement, he will look only the NDPS Act also. It doesn't a mandate provision. From time to time, it is also the duty of the district judge. He will also have to reshuffle the assignment which has been passed between them by the hand of the district judge authority. So we got two different interpretation of the bail. First, to ensure the presence of the person at the time of the trial before the competent court, and the other side, the court is also imposes their will on that person. He will not try to leave the jurisdiction of the competent court. That is the main reason you have seen in a different cases. Normally, whenever the court will grant the bail, and if the person is so much powerful, so normally the court order, Mister, you have also submitted your passport, because there might be a possibility he can flee, he can travel abroad. It doesn't mean the court is trying to restrict the movement of your freedom to move freely throughout the territory of India. It's just to ensure whether your movement from one place to the another place is still bona fide or the mala-fide intention. And still you are willing to go abroad, still you are willing to locate your city. So first of all, you will have to intimate the appropriate court through your counsel, and only the court will pass the order. Only after that you can travel from one place to the another place. If we also discuss the concept of bail, so we get it. The bail remains an undefined terms in CRPC. Already we discussed bail define किया ही नहीं गया है anywhere in CRPC. It's a clear cut. It continues to be understood as a right of assertion of freedom against the state imposing restriction, because it is the state government who makes the law for the welfare of their respective state, and on the other side it is the parliament who makes the law for the welfare of the country of India. So we can say that the state can impose a certain restriction over that person through the judiciary, because we know that very well. All the laws, if we talk in the sense of state government, if we talk in the sense of central government, so that has been passed either respective by the Parliament of India or the respective legislature of the state. So we can say sometimes normally state impose certain restrictions, and this is the basic fact of the bail. Even though the discretionary meaning of the bail denotes only a security for a person prisoner for his release. Now the question is that what do you understand by the meaning of release? What is release? A release is simply called release from the judicial custody. That means already either an complaint or either an FIR has been lodged against you, and the police took before the judicial magistrate. He or he saw your FIR, he saw the content, he saw all the facts, whatever has been conveyed by the prosecution officer, and judicial officer decided, no, it's time to send the person behind the bar. So whenever we will say or whenever we will use the term of the bail, so automatically we should presume like this. That means the person is already is behind the bar. Here I am talking only about the concept of non-bailable offences. Even though in a bailable offences, it's your right. Whenever the police officer is trying to arrest you and that offense falls within the purview of bailable offense, so this is the duty of the police officer to have explained you, mister, you have a right, and if you will do, then you are eligible to get a bail. And now what is the meaning of do? Suppose the police officer tell you have to arrange a surety, you have to submit personal bond, and you have to either submit your personal own bond. So these are the conditions which you will have to fulfill. If you are able to fulfill while you are staying at the police station, you will immediately get a bail before the concerned police station, only in a case of bailable offences. Suppose at that time you are calling some person who might be convert into your surety and he's not taking your call, and you are almost on the way to the court, and before reaching the court or before putting your matter before the competent court, if still you are ready to furnish the securities, furnish to bail bond, you will get a bail because it's a matter of right only in the cases of bailable offences. But you will have to fulfill, you will have to you can say fulfill your basic requirements as per the direction of either concerned police station or the either competent court, because already have they have set their respective norms, their respective regulations, their respective pro forma in different cases in the matter of the bailable offences. So we can say the bail, it's purely a conditional liberty. Up now, there is a two word. What is bail? We have discussed in detail. Object, already we have discussed. Definition, already we have discussed. Now, in finally, we are using the word, and the word is what? Bail, it's simply a conditional liberty. Isn't it shocked? One side, you are using the word of liberty. Liberty is what? Because we know that very well, liberty, it's a completely free of control. Nobody is going to watch you. Nobody is trying to impose their will on you. Nobody is trying to scold you. Nobody is trying to impose their wishes on you. That is called what? That is called liberty. Swatantrata. That means you are willing to do whatever you are wanted to do, but subject to certain terms and conditions. And here we are talking about the conditional liberty. So first of all, we should know what is the condition, whether that condition is universal or in the same condition this is apply. No, even in the recent judgment passed by the Honorable Supreme Court of India, when the honorable judges of the Supreme Court, they have seen a lot of bail application which has been passed by the different high courts. So what they observe while granting the bail application and while deciding the bail application by the different state high courts. So they just copy and paste the same terms and condition. And how this is practically possible in all the cases? Because all the person, they have their different antecedent, they have their respective financial positions, they have their respective criminal history, they have their respective social and economical status. So how this is practically possible if I am seeing 100 applications of bail which has been rejected by the below court of below, that is called the high court, and we shocked or we surprised in the 90% cases what we are seeing, the terms and conditions column or the paragraph is same. Then the honorable court has issued a guidelines. No, once you are deciding the bail applications, so first of all you will have to reason, or you will have to mention the reason on what kind of ground as well as the circumstances you are granting the bail application. And also you have to decide or you have to frame certain kinds of terms and conditions from case to case. It doesn't matter in a particular court number the 17 application has been filed, and in the 17 application has been granted a bail, and in 17 all the terms and conditions they are same. This is not practically possible, because each and every person, they have their different social status, they have their different financial positions. So how this is practically possible? And if just because of excessive amount, just because of excessive sureties, just because of excessive bond papers, the person is behind the bar, that means he is in a wrongful confinement. Although using the word of wrongful confinement is not in a proper sense, but we can say judiciary is not applied their mind. So while granting the bail, while deciding the bail factors, you will have also check and balance parameter, which has been varied from case to case, from person to person. And if we talk about the third new international law dictionary, so what it says about the bail, so it simply says the process by which a person is released from the custody. So now it's time to discuss the concept of custody. Custody is basically two types, either in police custody or either in the judicial custody. Normally we use the term of jail. Jail is what? Jail, it's a kind of judicial custody. And normally we use the term of remand. So remand is what? Remand, normally it's a kind of police custody. And in CRPC, it has been clearly stated out that, and that is what, maximum 15 days time period is allowed to police to get a custody of that person by the order of the court. And even after that, the police is really trying to inquire in context to the particular case, to the suspect person or the accused person. So he will have to visit to the jail authority. So custody has been already divided into two parts. First is the police custody and the second is the judicial custody. Judicial custody normally is in jail. That's it. And the police custody is what? Police custody is like a lockup, which we have seen in different movies or TV serials. There is a police station, there is a lockup, there is a tala, there is a havaldar who's standing just out of the particular barrack, which has been shielded by the iron rod covered. So that is called what? That is called lockup. That is not called jail. So whenever we use the term of judicial custody, so that is simply called what? This is called jail. And whenever we will use the term of police custody, it's simply, you can say remand, you can say a police lockup, but it should not be excessive more than 15 days by the order of the competent. So now the concept of bail we have discussed, the object of bail already we have discussed. Not in a good sense we can say definition, but it's a kind of interpretation of the bail already we have discussed. Now the question is that what is the offense? Isha, next slide please. Okay, if we talk about the concept of offenses, so we know that very well. The whole concept of offense has been divided into two equal parts. First is bailable offense and second is a non-bailable offense. Also, we know that very well. Bailable is what? Bailable is a matter in which you have a right to get a bail if you are ready to furnish all the basic requirements as per the conveyed by either the competent court or either by the concerned police station. And in the case of non-bailable offenses, in case of non-bailable offenses, only the court has a right to grant you bail. That is called discretion of the court. It doesn't mean that in a non-bailable offenses, whenever you will appear before the court and you will engage as some, high-profile lawyer and you will get immediately a bail. No, it's a matter of discretion of the court. So while deciding the matter of bail in a matter of non-bailable offenses, first of all, court will have to lick the copy of the FIR. He will have to check all the relevant documents, whatever has been furnished by the prosecution officer. It might also include the charge sheet. It might also include the charge sheet. Because whenever you will go to the high courts, so we have seen a number of cases in which the person is still behind the bar, and this is the rule has been laid before the CRPC, 60 days or the 90 days period of time, in which this is the duty of the investigating officer to complete their investigation and to submit the charge sheet before the judicial magistrate. Only after that the magistrate will take a cognizance. And Sometimes there is an unavoidable circumstances due to which the person is not well versed, he is not have a sufficient means कि he can engage a lawyer. So there is a lot of cases in which you can easily saw the bail restriction order has been filed, the case diary already has been filed, even though the charge sheet already has been filed, just because of lack of money, lack of knowledge, lack of source, and sometimes those circumstances which you cannot avoid it. So here we are discussing the offenses. So offenses, we know that very well. First is bailable and the second one is the non-bailable offenses. Bailable offenses, it is a matter of right to get a bail. But it is only applied when you are fulfill your certain terms and condition, whatever has been incorporated by the either respective thana or respective competent court. But in case of non-bailable offenses, it is the purely discretion of the court. First of all, court will look your matter. If the court thinks fit, this is a fit case for bail, they will grant you. If the court will see your case and think about this, this is not the fit case for bail, and this case needed a lot of more information, which is not available at present time. Then what will the court do? He will ask the prosecution officer or to the learned additional government advocate in the court of High Court of Judicature, either in Allahabad High Court, in Bombay, Madras, and respective. So in that kind of situation, the prosecution officer or the you can say the government advocate, they file a counter. They file a counter, and in counter is what? In counter, they collect a more and more information from the side of the concerned investigating officer, because there might be a possibilities at the time of the filing of the bail applications, only the copy of the FIR, the accused person is available, only the bail rescission order has been available, but that does not include, inquest report, postmortem, a statement under section 164, 161, and in some cases, case diary also includes, charge sheet also includes, even viscera report when the cause of death is not sure due to poison intake, or that person swallows some things which might be falls within the purview of list of poisonous substances, because while at the time of the postmortem the doctor is not able to get sure what is the actual cause of death, so normally they get a viscera report which has been reserved. So generally we are discussing the offenses, so we can say in a non-bailable offenses, it's a matter of discretion of the court, it's not a matter of your right. But it doesn't mean that you have to close your lips while your matter of bail is deciding before the competent court in the matter of non-bailable offenses. It means like that you have to show, you have to explain through your counsel why bail should not be granted to you, and that is the exact work of your defense counsel. This is the duty of the defense counsel, to show, to place each and everything before the competent court. This is the case of my client, this is the fact and this is the circumstances of my client, and my client is my client is deserve a bail, because already honorable different respective high courts or the Supreme Court of India, they have grant the bail, and we can say like this, they can use the word of precedence, because already on the same fact, on the same matter, it has been decided by the either the same court or by their different courts. So this is the basic rule that defense counsel, they have to show the valid reason before the competent court, because this is the duty of the defense counsel to defend their client. Because once I was just scrolling my Insta account, so I have seen a quote, or you can say it's a meme, during a trial, both the parties, they know their respective truth in the trial cases, basically it is the judge who is on the trial, because both parties they know their respective truth and they just try to linger on the proceedings, and it is the judge who is on the trial, and he will have to apply the filter. He will have to apply the filter by which he can get through the justice. So non-bailable offences, it's a matter of discretion of the court, and this is the duty of the court to grant you bail if all the thing is very crystal clear in the eye of the judiciary. Up now, it's time to discuss the complete discussion over the section of 436, 437 and 439 of the CRPC. If we talk about the concept of 437, 436, so already we have discussed. 436 is what? 436 is simply says in what cases bail to be taken. That is called what? In a bailable offences. If any act has been done by you and that act converted into omission and it comes within the schedule of the CRPC in the list of the bailable offences, so that means such person shall be released on bail, because in our bailable offences the police officer they have also right to grant a bail, but only the condition is that what we have earlier discussed, ki they will prepare some pro forma, they will prepare some rules, they will prepare some regulation, ki things which you don't do and things which you do. So normally they don't tell you what you do, but they tell you what you don't do. That means these. If you will do, that means your bail has been cancelled at any time. And that process has been already incorporated into the Criminal Procedure Code 1973. So normally the 436 it simply says that the bail in a bailable offences and it's a matter of right, but for that purpose you have to arrange a sureties, you have to arrange a bond paper, and if really you don't have a sufficient means, you don't have a well worth, you don't have a money, and you are really a indigent person, and if the court is believes over you, so you may also be released, or you can get released from the judicial custody your own personal bond. That is called what? That is called, now there is no need to arrange the sureties, there is no need to submit the bond paper in terms of the money and the other things like registration certificate of the vehicles, bond papers, bank fixed deposit and all that. These also includes while a person is trying to furnish their securities as well as the bond paper. So, but the condition is that suppose if the honorable court has granted a bail to you, you are behind the bar, 7 days has been left, and still you are not in a position to furnish either security, arrangement of persons who will take care of your guarantee, or also you don't have a bond paper. So normally the court will presume that no, he is a really one who doesn't have any sufficient means, and he committed such a bailable offense in which he has a right to be released on bail. So it's time we declare first that person is an indigent person, and they will release that person from the judicial custody. So judicial custody से release हो जाएंगे आप, but for that in the eyes of the court you must be looked as like an indigent person, like a besahara, the person who doesn't have any sufficient means to do whatever he wanted to do, because nobody is going to stay in behind the bar until he is not an habitually, or he is a, like the internal environment of the jail, because nobody is going to stay more than 4 to 5 hours behind the bar. Up now we discuss the concept of 437 of the CRPC. Up now, what is, yeah, why there is a need to incorporate the concept of 437 into the CRPC code? Because in the matter of criminal procedure code, the 437 deals in the matter of non-bailable offences, and in this only we file a bail application before the judicial magistrate. He might be magistrate of the first class or the second class, but not to the court of session, not to the high court. So basically, one side, the section 437 is saying to you the bail is taken in a non-bailable offences, because even though this is not your right, but this is a decision of the court. But apart from the other side, this is also your fundamental right to defend yourself in a very proper way, either through counsel, or if you think you are enough competent to represent yourself, so there might be a provision, there might be a possibilities that you can argue, but this is not practically generally impossible, whatever I felt in a person. So if we talk about the concept of 437, so basically it's clear cut indication bail in a non-bailable offences. The meaning of non-bailable offences clearly indicates he you should go to the judicial magistrate. Only he is the only one person who will decide whether you will grant a bail or not. Up now, normally the question is that in CRPC we have a different hierarchy level from the judicial magistrate civil judge junior division to the Supreme Court of India. All hierarchy, they have their respective limitations. Suppose 3 year, 7 year, 10 years. That means if I'm just giving you examples, suppose if the judicial magistrate, they have a power to conduct a trial of the offences for which the maximum punishment has been prescribed by the Indian Penal Code is only 3 year or 5 year. But the judicial magistrate, who is governed by the concept of the Criminal Procedure Code, they have power only to deal the matter up to the imprisonment of 2 years. So that means that judicial magistrate, they will not entertain your petition. They will refer your matter to the suitable judicial magistrate, who will have to look your matter, who will take the cognizance. Clear? And after that, your application of bail will be here. So here we are especially talking about the power of the judicial magistrate, not to the court of session or to the high court. I'm repeating again and again, that's why. Only to the judicial magistrate, not to the court of session or to the high court. 437 clear cut deals the power of the judicial magistrate. So normally what it says, ki any person against whom FIR has been lodged, he is taking before the judicial magistrate, and if the judicial magistrate thinks fit, there might be a possibilities he is innocent, prima facie a case is not made out against them, so that person may be released. But if the person who is accompanied by the police officer and on whom the offense of the respective Indian Penal Code has been imposed, and for that the punishment is either death or the imprisonment of life. So in these kind of cases, normally judicial magistrate, they don't have any kind of power to grant the bail, because it is the subject matter of the court of the session. So normally what they do, normally they reject your bail application from the lower court, then you apply to the court of the session. Now there are some other cases in which you can say you cannot easily get a bail. I'm here using the word of easily. Easily, that means you have to argue well before through your counsel. You have to place each and everything before the competent court, and all the things just like be in a crystal clear from there. But that means there is not a 0.1% of ambiguity, misconception, and any kind of hidden facts. So that is called, this is not an easy process. So this is not an easy process. It means here the judiciary, they will also have to apply their own mind while deciding the factors on which the bail application has been filed. So there is some other cases. Suppose if such offense is a cognizable in nature, and once that person is already in charge in bail in that kind of cognizable offenses, subsequently he was arrested in the same offense on the same charges, but in context to different person, different locality, or there might be possibilities the offense in which that person was booked, the punishment was might be death, imprisonment for life, or imprisonment for up to the 7 years of age. So these are the deciding factors in which the judiciary normally they look and they take care very well while deciding the bail application, because at the same another stand why the prosecution officer is also arguing on the same matter, and he is trying to convince the competent court in no your lordship, the offense for which that person has been booked now, for that the punishment has been defined either death sentence, imprisonment for life, imprisonment up to the 7 years, or this is not a this is not a decent person, this is that is a habitual offender. Earlier already that person has been booked, he was indulged on bail, and again that person is here, because in the same session we have already we will discuss the concept of gangster act, and normally we hear the word of criminal history. So criminal history is what? Suppose if today I'm committing an act, that act is an offense in the eyes of the Indian Penal Code 1860. FIR has been lodged against me. The police took take away me from my home. I was put behind the bar with the discretion of the court, and might be possibilities after 2 months, 3 months, 4 months, I will get a bail. And then what I do? There might be two ways I have. Either I should be completely convert myself into a decent way, like a Sarachari Balak, or I thought, already there is a stigma put on my head that I am not a good person. So it's time to do for what I did earlier, and for what I already enlarged on the bail. So this is the duty of the prosecution officer. He will have to explain each and every detail before the competent court. At the same time, when your defense counsel is also arguing on the same matter, because defense counsel is trying to find out you behind the bar, and the another side, prosecution officer is what willing to do, he wants you to stay behind the bar. But there is some exceptions also, in which the CRPC is clearly stated out that if the person who is behind the bar is a sick person, and if the age of the person is below the age of the 16 years, or if the person is women, sick, or infirm. Infirm is what? the person who is not capable to do their routine work, or the person who is suffering from any kind of disease. So if you have these kind of circumstances, if you have these kind of facts, so these are some grounds in which, or you can say with the help of these grounds, you can easily get a bail. You can easily get a bail, but the condition is what? Ki the person is under the age of 16 years, that person might be a woman, he is a sick man, or there might be a possibility ki he is also a infirm person. Infirm, already we have explained, that person who is not able to do their daily routine work in an appropriate way or manner, because already this concept we have discussed in the concept of a grievous hurt, in which the 8 exceptions falls, in which if the person who is laying on the bed for more than 20 days period, and he cannot perform their daily routine work, so obviously he is facing a grievous pain, grievous pressure in the form of pain. So already the hurt is directly converted into the offense of grievous hurt, that is called 319 converted into 320. So these are the some grounds. If you have these kind of grounds, so you can easily get a bill. It's not right. Just it's increase your chances. It doesn't mean that you are under the age of 16 years and you are very khunkar type, so you will get a bail. You are a sick person and you will get a bail. No, it just enhance your chances. Because if I say no, sick person is able to get a bail, so every person is make their medical prescription by the either government hospital or a private hospital, and he can easily get a bail. So ultimately, only the court will have to look into the matter whether that person, after adding these all the facts and the circumstances, is still liable to get a bail or the not. So accused person, while appearing before the court through his counsel, this is the duty of their defense counsel to place each and everything before the competent court in a very appropriate manner. Only after that the court will consider and they can grant the bail, but not a otherwise sense. Up. Now the question is that the right to be released on bail under section 436 clause 1 cannot be indirectly by fixing too high the amount of bond or bail bond to be furnished by the person seeking release. Already we have discussed if court knows that very well, the position of the accused or the suspected person, even the prosecution knows that very well, because first thing I would like to make clear, while we are litigating before the court, it doesn't matter who win the case or who lose the cases. Prosecution as well as the defense counsel, basically they both are assisting the court. You should not think one party has won the case and the another party has lose the case. No, this is the joint liability, or you can say this is the joint duty of both the prosecution as well as the defense counsel to assist the court to get the justice within a reasonable period of time. And what reasonable period of time has not been mentioned and has not been decided. So has already I have discussed earlier. So it simply says if the court knows that very well, the facts, circumstances, position of the accused or suspect person, despite of that he imposes a too heavy bond papers, too heavy sureties. He ordered, no, you will get only a bail until unless you will not arrange a 5 sureties. How this is practical for that person? And do you really think so? If the person who is already behind the bar, and how he will manage all the things behind the bar, and who is going to take the responsibility except their respective family members? So, Honorable Supreme Court has clearly issued a guidelines. No excessive sureties, no excessive bond, no excessive anything. Whatever you wanted to do, just do in your limit. And if a magistrate is satisfied after making an inquiry into the condition and the background of the accused that the accused has his roots in the community and is not likely to scorn, he can safely release the accused and order to appear on his own recognizance. Because in the society in which we are living, we have seen a lot of cases. Suppose when any person is went to the jail in the society normally in which that person resides a long time, nobody has come forward. Nobody has come forward to be the part of the surety. Nobody is coming to take the guarantee of that person. So again, this is the duty of the court to check where is the lacuna is present. Why, after granting the bail application, the person is still behind the bar? And if the court is think fit, you know, if we will release that person, he will follow all the orders, all the rules, all the regulation which has been accompanied by the bail order. So that means that person might be released on his own personal bond. But it doesn't mean that this concept is applies over all the matters. No, because judicial mind must be applied over there. Up another thing is that suppose if a person is granted a bail, so what does it mean? Do you really think so? He will not get arrested till the conclusion of the trial. If a person is granting a bail either by the court of judicial magistrate, by the session court, by the district court, that means district judge, or by the high court, or even the Supreme Court of India in the form of SLP. So what is it clearly indicates that person is free, whatever he wanted to do, he can do whatever as per their own wishes. No, it clearly means that this is the conditional liberty, this is the conditional bail. The moment you will breach any kind of conditions, any kind of rules, any kind of regulation, again you will send to the jail, and the concerned judicial magistrate, they will pass the order to the concerned police station to take him to custody and send him to the jail. So once a bail is granted, it doesn't matter कि you are totally free. You are under the surveillance of the court. You are under the surveillance of the judiciary. You are under the surveillance of the executive. You will enjoy your bail right till you will follow their norms. The moment you will break the norms, you will be thrown out before the jail. फेंक दिए जाएंगे आप. Nobody is going to stop you. And that is the main reason in CRPC already there has been a provision of cancellation of bail. And when we apply a file of cancellation bail, when that particular person already they have been granted a bail by the competent court and they are breaching the terms and conditions, they are avoiding the rules, they are misusing their liberty. So normally, anyone from the society or anyone from the family of the first informant or the victim family, they can approach to the competent court and they can file the application of cancellation of bail. No, your lordship, that person has been granted bail by your court and you have stated certain kinds of terms and conditions, rules and regulations, and that person also agrees at the time of submitting their sureties along with their bond paper, no, I will not indulge in any kind of activity which has been forbidden by the competent court. And what happened? He did, sorry, he is doing the same thing already he did in the past. And if the court is found, yes, this is truth. So while passing the order of cancellation of bail, he called the accused. Because already we know that very well, odi or trump partem, both parties should be heard and no one should be condemned without the process of the hearing. Up now, the question is that cases in the cases of non-bailable offences, that is called 437, in which normally the magistrate has a power, or we can say a magistrate has a power either to grant a bail or to reject the bail. Up now, we have already heard the word of interim bail. What is interim bail? Suppose if person files an a bail application, and we should know whenever you file a bail application before the competent court, so there is a certain period of time. We call them as a maturity period. It will take, might be 1 week, 10 days, or 14 days of period. But suddenly there is a arises the case of emergency in the family of the suspected or the accused person. So should he wait till the final disposal of their first bail application, or he simultaneously can apply to the interim bail? So there is a provision that if there is a emergency situation suddenly arises in your family and you are still behind the bar, your bail application till date has been not heard by the competent court, so you have a right to file a interim bail application. Interim bail application is what in which normally the court will grant you a bail for a limited period of time. But the condition is that the offense in which you have been booked is comes within the purview of, you know, travel in nature. Tuksh, chote aparad, small cause. Second, women, children, minor, aged parents, and there is also possibilities the student whose examination is going to be commenced. So for that point of view, normally the court will grant you interim bail. That is the limited period of time, might be 1 week, 2 days, 3 days, because it will take some time to dispose of your regular bail application. So you can say interim bail application is a small part in the form of the regular bail application, because whenever you will get a regular bail, so normally the court will write it an order key, your bail order in force till the submission of the charge sheet. Once the charge sheet has been submitted, again you file a bail application and you will play before the competent court key. No, your lordship, I have complied all the orders, all the rules and regulation, whatever has been incorporated by the competent court, and already in this case I received the order key. You will not get arrested or you will not put behind the bar till the submission of the charge sheet, and we know that very well, the time period of the submission of the charge sheet around 60 or the 90 days. Now the charge sheet has been filed. That means the trial is going to be started after that, taking cognizance by the competent court. So again that person file an application of the bail before the competent court. Your lordship, still I'm looking for your blessings in the form of bail, because I have obeyed all your orders till date, and still the trial has not been commenced, and only after the completion of the trial it will be decided whether I'm a guilty or the innocent. If I'm innocent, I will be freed from, and if I'm guilty, I'm ready to stay behind the bar. So normally the court will consider in the case of aged persons, children's, women's, let the trial must be completed, because there might be 1% possibilities the person whose name is printed in the copy of FIR, there might be possibilities he he may be declared innocent. So normally to whom we put behind the bar? The person who are suspected, the person who can temper the evidences, the person who can flee from the justice. Normally, we put those kind of person behind the bar, or to those persons whose verdict, whose final sentence has been passed by the competent court, either by court of session, high court, or the Supreme Court of India. So this is the concept of interim bail. Up now, the question is that ki, what is the process of 439? Because 439 gave the concurrent power simultaneously into the two courts. First is the Court of Session, which falls within the purview of District Court, and the second one is that High Court. Because in the 439 applications, you have powers. Either you can directly apply to the Court of Session, or you can directly apply to the High Court. But most of the advocates and most of the clients normally they prefer first to apply before the Court of the Session, because once your bail application has been rejected by the session court, there is still a chance to appear before the high court. But when your application of bail has been rejected by the honorable high court, then what you will do? You have only two options. Either you will file a second bail application before the competent high court, because you cannot back to the session court now, or either you can directly approach to the Supreme Court of India. But all the person, they don't have enough money, they don't have enough time, they don't have a proper knowledge of the law. So normally the person they prefer first to the court of the session. Even when we file any application before the high court, so first question which has been asked by the honorable judges of the high court, ki, Mr. Counsel, first tell me, have you applied before the court of session? If yes, then show me the bail rejection order. And if no, what is the special ground and what is your intention to come up before us directly before approaching to the court of session first? Because already we have a number of cases, because because we all know that very well, the number of high courts in India. If we took a ratio less than 1, because in all the states they don't have even their own separate high courts. So normally this is the question generally asked by the high court judges whenever any person file an application before the competent court under the provision of 439 of CRPC in the matter of the non-bailable offences. If you have a bail rejection order before the court below, that is called what? That is called earlier you have applied before the court of session. They heard your petition in the form of bail applications, and they couldn't get any kind of reasonable ground to grant you bail. So formally what they do, they just reject your bail application. Then what you do, you just take the certified copies of the bail order and you approach to the high court. I will discuss what kind of documents you will have to carry before filing before the high court. I will discuss all the things, because this is the third part in which we will discuss in detail any person who is going to file an application before the high court, what is the basic documents he must have to carry at the time of filing the petition, what is the role of deponent, who is the applicant, what is the duration behind the jail, and all that. So normally the 439 is clearly indicated about gives power to the two courts. First is the court of session and the second is the high court, because already your application of bail has been rejected by the Magistrate Code. Magistrate Code 437. Because in 436 we discuss the bail must be taken in a bailable offence. 436 in a non-bailable offences where magistrate court, and 438 anticipatory bail, and 439 is what? 439 is the power which has been given to the Court of Session and the High Court. Up now, the question is that ki, what is certain criteria to file the bail application before the High Court? Isha, next slide, please. Next. Okay. So here you can say there has been a PPT which is running over the slides. Essentials to file a bail applications. Essentials, that is not, you should understand that this is not a piece of paper. This is the process, because only the bail application can be filed before the court, not to the police officer. First of all, you should know about in the matter of non-bailable offences. Whenever you will approach to the court, so firstly you will have to go to the court of the magistrate. The court of magistrate, they will take their cognizance, and in most of the cases normally they decline or they reject their bail, because as per the provision of the CRPC they haven't given such kind of powers. Once your bail application has been rejected by the magistrate court, then you will approach to the Court of Session or to the High Court. And please, there is no confusion. Only one section deals for both the Court of Session and the High Court. First, normally the person will approach to the Court of Session, and if the Court of Session, they will not grant their bail application and they will reject, then they will approach to the High Court. Isha, next slide, please. Okay, up now, all the things which we were discussing till time, that is purely your subjective knowledge. It has been very well explained in your book, either in your Bear Act, in your respective study material, in your respective writer's book. But now it's time to file a bail application before the High Court under section 439 of CRPC. So I'm just going to give you a brief discussion over how to file to bail application before the High Court and what kind of precaution must be taken from your side. So the first page which you will have to prepare while filing a bail application, it has been clearly mentioned the first bail application in bracket section 439 of the CRPC, because normally the court generally they will not ask you, but it's your duty to tell the court that you have availed the right which has been given in the CRPC under section 439 of the Criminal Procedure Code 1973, and you are availing the benefit to file a bail application before the High Court, not to the Court of the Session. So the place where you will write in the judicature at Allahabad High Court, the same column you will also have to explain the provision in which you are going to file an bail application, that is called what? 439 of CRPC. Isha, next slide, please. Now, details of the defendant. Details of the defendant, that means the person who is at present time behind the bar. That means the person is in the judicial custody. You will have to mention the detail of the person who is behind the bar. That is the name of the person, the name of the father of the person, the age of the person, and the address of the person. This is the prima facie, detail of the applicant. And we can also hear the use of word defendant despite of applicant, because applicant is the person normally who is going to file an application before the court for the purpose of granting their bail. So in the column of details of the defendant oblique applicant, you will have to write it down. The name of the accused person who is behind the bar, the age of the person, the name of the father of the accused or the defendant or the applicant person, and the current, present, or permanent address of that person. Next slide, please, Isha. Okay, certified copy of FIR, because also we know, also we call what, your lordship, my lord, my lordship. And sometimes most of the courts, so they have objected their counsels ki, instead of calling my lordship, you can use your lordship, or you can use word sir. I don't have any kind of objection, because one side we are calling them huzur, bhagwan, you know that very well, but we should also know that very well, he is just a juristic person, he is not a god, he doesn't have three names as like a Bhagwan Shiv Shankar ji. So whenever you will appear before the court, how the court will know by what kind of grievances you came before us? So at the time of filing bail application, the certified copy of FIR must be accompanied in your application. The copy of FIR is what means? The FIR is means first information report, and it has been mentioned in the provision of section 154 of the CRPC, even though the word FIR has not been mentioned and has not been explained in anywhere before or in the Code of Criminal Procedure 1973. So certified copy of FIR, that means there must be a stamp by the competent court who will issue the authenticity of the copy of FIR. Otherwise, you know that very well, technology is too advanced. Suppose the FIR has been lodged in the non-bailable offense and the person is too highly technically sound, and what he will do, he will just make a false copy of FIR, and where it will mention only a bailable offenses. So these kind of confusion must be removed. For that kind of purpose, normally this is the direction has been issued by the court. Only the certified copy of FIR must be accompanied while filing an bail application. That is called what? A blue color stamp must be there along with the signature of the person who issued the certified copy of FIR. And it doesn't mean you will get only one copy of FIR. Number of copies, whatever you want, as per your requirement, you can get it by the competent court. For that, you have to pay a certain kind of amount as per the prescribed by their competent court or prescribed by the respective their government officers. So FIR must be a mandate provision. Without FIR, rarest of rare chances, no judge is going to look into your matter, because whenever you submitted your bail application, the dais on which the judges open your file, first of all, he will look your index and he will saw where is the copy of FIR, and he will just recite the copy of FIR, and he will look what kind of sections has been imposed over you and what kind of punishment over is there. Next slide, please, Isha. Apart from that copy of FIR, if you know that very well, once the FIR has been lodged by the concerned police station, you know that very well, whenever we write an application in context to non-bailable offences, so normally we use to the SHO, that is called station house officer, and You know that very well. In each and every station, there is a one SHO. Under their number of darogas or the sub inspector, we can also call them investigating officer, were performing their duties. So normally what the SHO does, he just assign a work to the one daroga, that is called investigating officer. This is the responsibility and this is the legal duty of the investigating officer. He will have to make a separate diary. He will have to make a separate diary in which he will write it down day to day affair. आज कहाँ गया, कल कहाँ गया, किस किस के स्टेटमेंट उसने लिए. He will write it down all the details, and these all are collectively called as a case diary. In short, you can also call CD. CD, it's not like that कि you put it into VCR and CD player. CD in the legal terminology, it is called a case diary, in which not the SHO but the concerned investigating officer, IO, or you can say Daroga Sahab, they will roam around their respective jurisdiction. They will collect the evidences, they will collect the statement of their respective witnesses, and all the statement, whatever has been recorded by the investigating officer, they fall under the provision of 161 of the CRPC. Next slide, please. Okay. Now, statement under section 164, and the use of 164 is normally we look into the matter of offenses against the women, because the statement of 164 must be always given before the judicial magistrate. You can also understand in this kind of way, suppose a lady is approaching to the police station and she is the victim of rape or the, you can say, sexual assault or the sexual harassment. So immediately while lodging the FIR, this is the duty of the police officer just to take that lady and appear before the judicial magistrate. Before that, that lady will narrate all the things which is necessary for the purpose of this case. That is called statement under section 164, because it is the presumption in the police custody they can they can do whatever they wanted to do. They can threat you, they can scold you, they can abuse you, and due to threat, due to abuse, and due to the process of scornment, you can change your statement, you can change your views, but this is not practically possible into the case of judicial magistrates. So normally is these kind of situations, 164 statement plays a stone role, plays a very important role while deciding the factor of the trial of the case. Next slide, please, Isha. Okay. Now, here is the word of the charge sheet. Charge sheet is what? We discuss the concept of FIR, not in a broader sense, but in a very smaller sense. We discuss the concept of 161 statement, because basically it has been collected by the concerned investigating officer. Normally, we discuss the concept of 164 statement because normally it must be given before the judicial magistrate. Now it's time to file the charge sheet. Charge sheet is what? The moment when the investigating officer has lodged the FIR as per the direction of the station house officer. After that, what he will do? He will investigate the case, because inquiry is a work of the court, trial is a work of the court. So normally, what is the work of the police station? Just to investigate the case. For that purpose, we have already settled a limited period of time, 60 days or 90 days. In that kind of period, that concerned investigating officer, he will have to complete their investigation and submit their report to the concerned SHO, in by whom under he was supervising his duties. So you can say charge sheet is what? It's a completion of your investigation process. Now you have done your investigation completely. There is no need to further investigation as per their own point. There might be possibilities. The judges may ask to further re-investigation or re-examination of any witnesses. There might be possibilities. So charge sheet is what it has been incorporated under section 173 of the CRPC, and basically it indicates the investigating officer has done their duty. It's time to submit their papers, which is very important for the purpose of the trial. So normally what he do, he will submit his charge sheet to the SHO. They will again submit to the deputy SP or the DSP, deputy superintendent of police, and when the DSP will look all the files, he will put his signature because he is the superior rank officer. Then he will transmit all the files or the respective files to the concerned judicial magistrate, who will first look into the matter whether that matter is the cognizable or not. If the judicial magistrate will look into the matter and they think fit, no, this is the matter of the cognizable, we have to look into this matter. So they will first take the cognizance, and after that they will start the trial. Okay, Isha, next slide. Okay, now it's called inquest report. Inquest is what? Suppose someone is died due to accident, suicide, animal attack, acid attack, murder, any medium by which he can directly meet to the God. कोई भी माध्यम. Okay, then first of all, any passenger or any trespasser or any person who is just passing the way and he saw that no, there was a dead body laying over the track. What he will do? First, he will make a call to the police officer. Police officer will come, and first of all, he will make an observation. What is the opinion of the 5 persons? Panchnama ya panch, you can say, inquest report aap kahe, that is much better. Inquest report, matlab what the 5 person, what the investigating officer, or what the police officer who got a call regarding such and such kind of incident, and what he thinks, because post-mortem process is too far, because in all the cases post-mortem is not necessary until and unless there is not a certainty of the cause of the death. So inquest is what the investigating officer, what the concerned police officer who just visited on the spot, as their opinion will be recorded in the form of paper. What you think? He will look the body, he will rotate the body after taking a precaution. He will observe the body, and then he will make a report. As per my own opinion, there might be possibilities his opinion will be completely struck down in the medical examination or in the court of the trial. So he will just try to make, or he will just try to write out down their own opinion. As per my views, you normally, whenever you try to download some kind of application from the Play Store, and whenever you are willing to purchase any kind of goods, whenever you are willing to see any kind of movie, so normally you see the ratings. You are willing to see the ratings. You are looking all the comments, whatever has been incorporated by the different person from time to time, to whether this movie is worth for you or the not. So basically, the person who post their comment, the person who gave their ratings, so normally they express their own views, what they think about that. It doesn't mean you should also follow what they are thinking. So inquest is what? Inquest is a simple process in which, after seeing the dead body of the person, the police officer who is available on the spot, what he thinks, what his view, what his opinion, what was the actual cause of the death. Yeah, what was the reason behind the death of that person. This is called simple inquest report. It does not include any kind of medical DNA sampling and all that. It is just a process of the post-mortem. If that must be conducted after the permission of the concerned court or the respective station house police officer. Isha, next slide, please. Now, this is one of the most important factor in the criminal jurisprudence, that is called post-mortem. You have gone through the concept of the Indian Penal Code. If we talk about the concept of miscarriage, hurt, grievous hurt, attack, acid attack, murder, culpable homicide, 307 attempt to murder, 304B causing death, dowry death, 304B dowry death आपका होता है. So normally in all the cases, if you are really willing to fight a trial, and if you are very faithful towards the justice, so post-mortem plays a very important role. Basically, it is only a post-mortem who will play as like a brahmastra, a hukum ka ikka. Because while considering the bail application either in 302 of the Indian Penal Code, 304B, grievous hurt, causing miscarriage, normally the judges will look the post-mortem report. And I'm extremely sorry here. Post-mortem, that means the person is not surviving. Already he's died. So this is not apply in the case of grievous hurt because already the person is living. If he dies, normally the post-mortem will conduct. Causing miscarriage, if both the mother and the respective their child who is in the womb of their respective mothers, again post-mortem will be done. 302, इंसान चला गया, already post-mortem will be done. 304B, dowry death, already the lady who is a victim of dowry demand, cruelty, sexual harassment. So normally within the period of 7 years, whenever she died, so normally this is the presumption which has been taken by the court if the FIR has been lodged by the side of the victim of the family. Might be his brother, his father, his any one of the family members. So in these kind of cases, normally this is the duty of the station house officer or this is the duty of the concerned police station officer. If there is not a clear indication of the cause of death, then in this kind of situation, the post-mortem must be conducted because post-mortem plays a very important role. You can say a post-mortem can actually convert your case completely. And in 302, 304B, in all the cases, judges normally look their post-mortem. In the case of hanging, whether it is a purely case of hanging or it's a case of nabbing your neck, it will only decided by the post-mortem report, not with the help of the inquest report. Isha, next slide, please. Okay, site plan. Site plan is what? Basically, site plan is a location in which even that person has been died or the offense has been committed or the actual occurrence of offense has been still going on or you can say continued. So site plan basically normally because this is not practically possible for the judges to leave their chair to go on the spot and to look all the matters. So again in the case of whenever we will file a bail application before the courts, so normally what the concerned investigating official do, they also prepare a site plan look, your lordship, look, honorable sir, this is the room where the victim has been died. This is the place where a fight has been took between the two samudai or two group of people. This is the place where a victim has hanged himself or his self. So site plan is also very important role, because for this kind of procedure, the judges can imagine ki what could be happened at that kind of place if the lock was locked inside the room, all the windows they locked inside the room. How this is practically possible for outsider to go into that room, to kill that person, to come out of that room, and again he locked the room inside with the help of Chatkini and Danda. So site plan is also important, very important role. Isha, next slide please. Okay, now the criminal history of the applicant. Applicant, who, you know that very well. Applicant is the person right now who is behind the bar and who's seeking the mercy of the court in the form of the bail application, either by the court of the session or either by the high court. History, that is called antecedent of that person. Criminal, that means आज से पहले उसके ऊपर कितने अपराध ऐसे हुए जो दर्ज हुए हैं, and how many times he has been already earlier booked in their respective offense. That is called, suppose if a person file a bail application before the court, so normally the court looks the para in which the counsel of the applicant wrote a line, your lordship, there is a no criminal history of my applicant, and if there is a criminal history, that means there is a more than cases at present. There has been a more cases at present. Then in this kind of situation, the judges will ask to you, Mr. Counsel, will you please try to explain in the earlier cases what was the position of your applicant? Either he has been convicted, either he has been enlarged on bail, or either he has been proved guilty. So criminal history para is also a very important, play a very important role while drafting a bail application before the High Court. Okay, so next slide please, Isha. Okay, now the last part is that a practical point of view. Okay, I'll do that. Thanks. Okay, bail rejection order. Suppose if you are filing an bail application before the court of session, that means while filing an bail application before the court of session, you will have to attach copy of FIR, you have to attach copy of 161, 164 as per their respective offenses, because in all the cases 164 is not mandatory. Please keep in your mind. Apart from that, if you have the copy of charge sheet, if you have the copy of case diary, if you have the copy of inquest report, if you have the copy of the postmortem, if you have the copy of site plan, if you have the gang chart, which has been issued by the concerned state government official website of the police authority, in which a detailed description has been mentioned, how many times you have been booked, under what kind of provision, under what kind of circumstances, and what was your position in your earlier previous cases. Still you are on bail in earlier cases, or your trial, what was the stage of your trial, ये सारी चीजें you will have to attach it. अब now the question is that if you are filing your bail application before the court of session, that is called what? That is, in last you have to attach your last bail rejection order that is passed by the court of magistrate. And if you are filing the bail application before the competent high court, then you have to attach the certified order of the bail rejection order of the session court. Look, all the things which we have discussed, They all are the part of the Criminal Procedure Code. We have discussed the whole concept of bail into three equal parts. In first part, already we have discussed what is bail, object, interpretation. We will not use the word of definition. And second, 436, 437 and 439. Because in 436, we deal with the concept of the bail in a bailable offence. 437, power of the magistrate. 439, power of the court of session as well as the court of the high court. And in the third part, we discuss the entire concept of the practical aspects for being a lawyer. How will you draft a bail application before the court of session or before the high court of judicature at any court? Allahabad, Bombay, Calcutta, Bengal, anywhere. And what is the basic documents which you will have to carry? Because if these kind of documents which we have discussed here, if you will not carry, your bail application must be dismissed at a first instance by the court of the registry, from where you go and file your bail application. If you have not attached the certified copy of FIR, dismiss, reject, वहीं पे reject हो जाएगा. They will put the cost, because this is the duty of the RO or the assistant review officer or the review officer. He, while placing or before placing the actual bail application copy before the dais of the court, they will check whether you have complied all the provision regarding the drafting of the bail application. If yes, only after that your bail application will be placed before the honorable judges. Otherwise, they will put a cost or they will text you on your registered mobile number कि Mr. Counsel, you just approach to the concerned registry department because there is an error in your bail application. Please come and remove it. So it's all about concept of bail, theoretical, practical, and the procedural aspects point of view. And our next session will be conducted, I think, day after tomorrow, in which we will discuss the detailed concept of anticipatory bail. Because where there is apprehension to any person, there might be possibilities that he put behind the bar or he might be get arrested at any time before the police officer. So our CRPC, they have also provided, a weapon to that person. They can also apply before the competent court in the form of anticipatory bail application. That means in the event of the arrest, if he will furnish all the basic requirements, in the event of the arrest, if he will furnish all the basic requirements, so that means he will be instant on the spot, be released on time. That means he will not be thrown out. Yeah, he will not be thrown in behind the bar. So Isha, hello.
Hello?
Isha, so I think it's all about the concept of bail, and if there is any question, so I'm ready to give the answer.
I don't have any questions.
Okay.
But thank you.
Okay, Isha, thank you so much.
Thank you so much for your speech today. It was very interesting and entertaining, and I hope that everyone else enjoyed this as well. Thank you so much.
Thank you so much, Isha. Thanks a lot.
Thank you.
So